And thanks for everyone in the audience and for those.
Hold on.
Unmuted lines.
We can hear you, right? Okay, so let me. I can turn on.
Did you unmute it?
No.
Okay.
Did I mute you now? Are you there, Ian?
Yes, I'm here. Hello.
Okay. Okay, you can take it away. So.
Okay, great.
Over to you.
All right. Well, thanks again. Super excited to be presenting to CodeX, and thank everybody for tuning in. We are Specifio. We are transforming the way that patent applications are created. Start with a quick snapshot of the company.
Turn off my video.
Advance. So, so the company was founded in early 2017. I think we might have a couple lines that are unmuted. You could switch that off.
Give me a second. I've tried to mute.
No, I think it's just him.
No, I think you're the only one currently with
okay. All right.
the mic on.
The bottom left icon for mute isn't on your screen, or it's on. It's not on the main screen, rather. Main camera.
What?
There's a camera that's pointing. That camera there. The little mute button is in the bottom. Isn't? I don't see it in the bottom.
Yeah, like our microphone's on,
Yeah.
but that might be the one you're talking about.
Yeah.
No, he's good.
Yeah. Do you get interference?
Nope.
All right.
Go with it. So anyway, so we were founded earlier this year, actually on Valentine's Day. A little background on myself. I'm a patent attorney by training. I practiced for 10 years. I started out at a Silicon Valley boutique called Carr & Farrell. Spent a few years there and then moved to a global law firm called Pillsbury Winthrop. Practiced for 7 years there and just left there in January of this year. My background is in physics, my formal technical training. However, my interests have gravitated towards artificial intelligence and specifically in the area of natural language processing. Kevin, my co-founder, is a leading expert in computational linguistics. He's the director of natural language technologies at USC's Information Sciences Institute. A little background on how we came together. Actually, when I was just starting practicing, Kevin had a startup company called Language Weaver that did statistical machine translation. And I was lucky enough to be able to work on a patent portfolio for about a year. So that was our initial connection, but we were out of touch for several years, but kind of reconnected last year. So Specifio is a natural language generation company, and we're focusing on patent preparation. We're currently incubating at USC Information Science Institute down in Marina Del Rey. It's a part of the Viterbi School of Engineering. We were founded earlier this year. We did a kind of a limited push into the market at the beginning of summer, and got some excellent feedback from our early adopters, and spent the summer kind of hardening our system to make it a little more enterprise ready, to boost the reliability and versatility of our service. Our first big push into the broader patent ecosystem was actually earlier this week. Let's see. We had an exhibit booth at the annual meeting for IPO. That's the Intellectual Property Owners Association. It's kind of the who's who, or the royal court of the patent world. There were kind of the patent leaders from major corporations, intellectual property section leaders from
Sorry, Ian, I accidentally turned off your video. Are you still there?
Yeah, I'm still here.
You just said, oh, there you are. Okay, great.
How's that? Okay, so at IPO, it's the kind of big ones in patents for major corporations, major law firms, and then the service providers that serve those folks. So this meeting was actually earlier this week, Sunday through Tuesday, and while we were at the booth, kind of fielded tons and tons and tons of questions, and had a great chance to give a demo of our service. But a couple themes started to emerge in the questions that we were receiving, and I think that this is kind of a shorter format, but by giving you the answers to those questions, I think that it'll give me a chance to introduce our company. But also the issues have a little broader applicability to other companies that are working in document automation, specifically on the legal side. So here's a kind of a dim picture of our humble booth. So typically people would walk up to our booth and read the first line of our backdrop, say automated patent drafting, and then follow that statement with one of these three questions. So it's either, okay, so you are the guys that are going to put me out of business, or how is this supposed to work, or what about confidentiality issues? So I'm going to walk through each of these questions, and then we can open it up for questions from the audience. But before I do that, let me give just a super quick background on patents for those that aren't super familiar with the area. So patent applications are written documents that explain an invention. They're typically 20 or 30 pages long, and they have three parts. They've got a claim section, what's called a specification, and then drawing figures. The claims are numbered sentences that define the invention. They got their name based on an analogy to real estate deeds. So if you have a deed for land, there's a definition of where are the boundaries of the piece of property. And it's either given by coordinates or land features, but it somehow defines the extents of the property. So with patent claims, the idea is to kind of define the boundary between where the invention ends and where the prior art begins. So they're very carefully worded, but that's kind of that's what claims are. The specification is then a long body of text that explains how to make and use the invention. And then the drawings go along with the specification. They are typically super simple drawings that have numbered elements that correspond to the description in the specification. So typically, patent applications are written by highly paid, legally trained engineer scientists. If that person has a law degree, they're called a patent attorney. If they don't have a law degree, they're called a patent agent. But the U.S. Patent Office, they're treated in the exact same way. These documents typically take about an hour per page to prepare. So if you have a 20-page patent application, you're looking at about a half a week of work. The process that a patent attorney uses when he's approaching one of these projects is to first digest the invention. So that can take the form of an examiner, or excuse me, an interview with the examiner, review documentation on the invention. However the patent attorney can kind of take in, absorb, what is the invention. The next step would be drafting the claims. And claim drafting is not, it's not just an exercise of putting words on paper. It's a bit more of, I would say, an art form. Kind of a rule of thumb that I always heard when I was practicing, that it takes about 4 years before an attorney gets really good at drafting claims. And it's not something you can read in a book. It's something that you just have to learn by doing. Typically, it's kind of like an apprentice approach where you're working under someone who's a master at this task and kind of teaches you over time how to do it. When an attorney is drafting claims, they're thinking about a ton of things. You know, it's not just what is the invention, what's the like core inventive concept of the invention. They're also thinking about things like what is the business strategy of the client? What competitive products are we aware of that that might be relevant to the claims that we're drawing? What are the prior art that we're aware of? The list goes on. What's the right words to use to describe the invention? So all of these topics are kind of swimming around in an attorney's head, and based on those factors, the attorney creates this numbered list of sentences, the claims. Once the claims are done, though, going from a claim to a specification is a pretty technical process. So the requirements for specifications are statutory. They fall under 35 USC 112. And an example of a requirement is the specification needs to enable the invention. So that means the invention is described in a way such that one of ordinary skill in the art would know how to make and use the invention without undue experimentation. So that's kind of the threshold for these specifications. Here's a background on patents. So back to the questions that I was getting. Is this going to replace patent attorneys? My answer is an enthusiastic no. I practiced for years, and I'm very familiar with what goes into a patent application. I'm also very familiar with kind of what is bleeding edge in natural language generation, and in my view, patent applications in general are patent attorneys, I guess, deal with a level of nuance that would just be very difficult based on the technologies that are out there, at least, to kind of do what an attorney does. So the big idea behind Specifio service is that in the writing task of preparing a patent application, there's a clear boundary between the judgment and creativity-driven portions and the mechanical writing portions. So we want to leave judgment and creativity with the human. That's an attorney's value add. That's where their experience comes in. We want to kind of leave that intact. The mechanical writing portion, however, is where our automation comes into play. So kind of the outcome, or at least what we hope to be the outcome with services like this, are that it actually improves the attorney's experience. They have better job satisfaction. They spend less time doing these kind of boring writing tasks, more time doing the high value intellectual heavy lifting that you want to do when you think you're going to do when you're at law school. Because we're cutting out this mechanical portion, we can drive more work through learning, and by doing that, boost profits. Patents are kind of a unique area where the billable hour is becoming less and less popular, and these documents are priced more based on like a market rate. So if you can do 5 applications in a day instead of 1 application in a week, but sell them at about the same price to your clients, then then there's room for boosted profits on an hourly basis. It also allows these firms to deal with fluctuations in workloads. So a lot of times firms will hire enough attorneys to handle the work at its max. But workloads at law firms kind of go up and down, right? So in the down periods, you've got a bunch of attorneys that are kind of underutilized. And so if you can, say, staff for the minimum level and then use technology to deal with those ebbs and flows in the amount of work coming through the law firm, then because of so talent retention and leverage are also big areas. Happier attorneys want to keep their jobs. And then on the patent applicant side, they get faster turnaround. You can give them an application, say, tomorrow instead of in a couple of weeks. So moving on to the second question, how does this work? So the short answer is we use cutting edge natural language generation technologies. Our system is fully automated and it actually operates over email. So, I worked at a law firm for many years, and lawyers sometimes are a bit technophobic, but they all know how to use Microsoft Word and they all know how to use email. So we created our service to kind of cater to that. So the way that it works is a patent attorney drafts the patent claims. That would be the high value part of the exercise. Attaches those claims to an email and sends it to our automated system. Our automated system receives the claims, converts it to a patent application that's ready to be finalized in files, and then emails it back to the attorney in about 2 to 5 minutes. So that's a process that's maybe 20 or more hours and brings it down to maybe 5 or less. We do expect some amount of post-editing. So the claims are drafted. We've then provided a fully drafted patent application, and then the attorney may go back, proofread it, maybe put in some extra examples or whatever might be their secret. But the point is that we can compress the writing process drastically. It's kind of like you get 20% into the project and then just fast forward to the end. All of a sudden you're 80 to 90% done, polish it off, and you get the project off your desk. With respect to the last question, what about issues like confidentiality? So our answer to that is that full automation kind of solves a lot of these issues. And the reason that full automation is significant is because there's no human intervention, right? So at the patent office, for example, every person that is materially involved with the preparation of a patent application has a duty of disclosure. So that means each of these people has a duty to inform the patent office of anything that might materially affect the patentability of the claimed invention. If there are no humans involved with that, then that duty of disclosure kind of disappears. With respect to confidentiality, it's kind of the same issue. So with or same solution, I guess. With our system, our registered users password encrypt their documents, send them to us. Those documents are processed and patent applications are returned by email. Those documents that we return are also password encrypted. We never see the content that's being sent in, and we don't want to see it. Patents are an area where there's tons and tons of training data. we don't need more data to train on. We've got millions of patent applications that we can work with. So the confidentiality is secure in that way. And then the third big area is with respect to conflicts. If you have a solution that involves a person, say let's say we were doing 10 patent applications for company A, and we had a human in the middle. So the human could see what was coming in, what was going out. And then we're doing 10 applications for company B. If company B is a competing company, company A, I think would have a fair concern that that there may be some trickle of their information into company B patent application. Whether it's actual information or just kind of that person taking into account what they just learned and applying it in some way to B. So if there's no human intervention, that conflicts issue also kind of goes away. So that is kind of the short story of what we're doing at Specifio. And I'd be happy to take any questions from the audience at this time.
Sure. That's very cool. Anyone has any question for Ian? You want to show that? What's your business model?
Subscription, right? So we started out thinking that we were going to do transactional, but it's an accounting nightmare for us and for our customers. For example, in claims, gets back a specification and then decides that they want different claims or slightly modified claims. We don't want to ding them twice for that. We don't want them worrying about, incurring more costs. We just want them to use it. So we do a subscription.
So I think there's, a lot of IP lawyers that I know, they keep a lot of templates for like different, sort of the repetitive parts in patent applications. And the problem is like managing those templates then, right? And then, because they get outdated and everyone in the firm has their own templates. And so, you sort of like, does your system kind of solve that problem? Because that people won't need to keep any templates anymore. Because it always creates it from your database of patent applications. It takes the most appropriate language for the specific case.
One thing I didn't mention that I definitely should have is that at this time we're operating only in the software patent domain. So patent applications covering software-related inventions are about 20%, maybe a little over 20% of the patent applications that are filed. So we're only operating in this space right now. Down the road, after this technology is proved out, we'll start moving into other areas. But regarding the templates, yeah, I guess that there is no need. I mean, all that attorneys need to do right now is provide the patent claims.
Mm-hmm. And does your system do automatically also the prior art search then? No.
No, we're only natural language generation. So there's actually a lot of really cool new companies out, also leveraging neural networks that are doing some really cool stuff with prior art searches, infringement detection, things like that. Not us. We're strictly a natural language generation company.
Cool. Any other questions?
Yeah, I was wondering, how does your system approach like the drawings? So you're just generating flowcharts? Like you said, you're just based in like the computer space. I could see it more like a mechanical patent. You have a lot of like reference characters and stuff. Is that kind of what you've stuck to this?
So right now, because we're in the software space, only working with software-related inventions, our input is a single set of method claims. And from that set of method claims, we create a patent application that supports the method and also a system that performs that method. So our specification has a very long description of a system, providing the kind of baseline 112 support that's needed for this area. And then the figures are, the figures also reflect that. So we programmatically create two figures. One is kind of a generic computer system that illustrates the functionality of the computer system. And then our second figure is a flow diagram, that corresponds to the method claims.
Ian, can you show a demo? Very quickly. We have like 3 more minutes, but I was just...
I can. Let me pull this up. Just bear with me 1 sec. I've actually got something that should work well. Right. This will take just a moment to pull up. All right. Okay. Here we go. Can you all see this Gmail inbox?
Yep.
All right, great. So these are some. This was like my demo for the conference. Let me just expand this. So these are a set of sample claims that I sent in. Let's say of method claims. Right, so one independent claim and then as many dependent claims as you want. So in this example, there's 2 pages of text and 10 claims total. So I sent this Monday morning. I sent it in at, my timestamp's down. So I sent it in at 6:03 in the morning. 5 minutes later at 6:08, I got this reply email with specification and drawings attached. So if we take a look at the specification, we went from 2 pages to 23 pages in 5 minutes. Every section of the patent application is filled out except for the background section. It's an optional section and attorneys can do whatever they want with it. The summary captures the system and the method independent claims. We go on to the detailed description, which, as I mentioned, starts with a nice, meaty discussion of the system. The way that the content is organized, so we take in the claims and kind of chop them up and divide that information into different functional buckets. And each of those functional buckets is described separately as a software module. So you can see here all the modules that we've identified. All these names are appropriately given. This is all computer generated. And then each of these software modules is described individually. Moving down through the specification. So after the modules are discussed, there's a couple pages of, not exactly, but more or less canned language that provides kind of required support for inventions in this area. So simple things like what's a processor, what is memory, things like that. And finally, in the detailed description, there's a section describing the method, corresponding to the method claim. But each of the main steps of the independent method claim are described. Go down to the claims, and we get whatever we receive, we give back double. So if you give us 10 claims, we'll give you back 20. If you give us 1 claim, we'll give you back 2. 100 claims, we'll give you back 200. Creating system claims that mirror the method claims that we receive. So here we have claims 1 through 10 that are a system. All these claims are automatically computer generated, and then claims 11 through 20 in this example are the original method claims that we receive. Finally in the document is the abstract. If the abstract is more than 150 words, we tell you, but we let the attorney whittle that down. And then looking at the figures, let me pull those up. This is a PowerPoint document, so totally editable. It actually looks better in PowerPoint, but I think you can get the idea in this Gmail rendering. So this is a generic computer system. This is typically how, typically the type of figure you would expect to see in a software-related patent application. And then all of the software modules that were described are also illustrated here.
Cool. Ian, we have to, yeah. Do you want to just finish us showing
the last?
We have to like wrap it up. I'm sure there's like a ton of questions that people might have for you, and I just want to let you finish your thought. But maybe before you go, if you could just put your contact information in the chat, so that if people want to reach out to you,
okay,
they can reach you. But sorry, please finish your thought. But then we'll have to turn it over to Ruben.
I was almost done. So this is it. This is the second figure that we create. It's a flow diagram that corresponds to the independent method claim. So this is, it's kind of like the meat and potatoes of a patent application. It's what has to be there. An attorney could pick this up and add in another figure, some examples, and be done with it. So
cool.
That's it.
It's very cool.
Yeah.
It's very cool. So, well, great. Well, thank you so much for your presentation. It's really great. And so if folks have any more questions, please send Ian an email. And yeah, I look forward to seeing you around here.
Great.
All right. Thanks a lot, Ian. Appreciate it. All right. So let's turn it over to Ruben.
Right.
So, Ian, if you could unshare your screen, please, that'd be great.
And you want to just stop recording?
Okay. Thank you. Okay. Hold on. All right.